regarding employees, especially essential workers, returning to work or participating in any activity? Can they refuse the order to work if they're not equipped with sufficient PPE? Um, and what if they refuse to work until the vaccine is available? Can they be fired, especially if they have underlying medical conditions? So that's pretty much a nice Big Mac of a question, but
Sure. Just to kind of break it down, I mean, in general, forget COVID for a second, put all that aside. If there's an unsafe working condition, certainly OSHA, which is the Occupational Safety and Health Administration, and there's a Maryland equivalent, MOSHA, Maryland Occupational Safety and Health. Um, they could step in, and the questions are, I mean, there's a four-part test as to whether or not the employer is acting reasonable, whether there's an unsafe condition, whether it's been properly addressed, and whether the employee's refusal to work is unreasonable. And we are sort of living in uncharted waters, or navigating uncharted waters right now. And I think unfortunately, as we have discussed, there are no bright line rules in most of the law. What's reasonable and what is reasonable care? When I'm driving down the road and you're coming the other way, I have to use reasonable care to not cross the double yellow line and hit you. When you own a business or a premises, you have to have reasonable care, use reasonable care so someone doesn't fall down the stairs if you have a broken step, for example. So I think in this position, if a case ever got to court, what would a court be looking at? Well, we would be looking at, number one, was the employee's assessment or was their fear of this risk, was it reasonable? And number two, and more importantly, because I think right now people are going to side, especially with small businesses. Now, it may be a different analysis with a big hospital, nursing homes, these big conglomerates. But right now, I think the idea is going to be to protect the businesses. And the question a court would ultimately have to resolve, a judge or a jury, is, did the business take reasonable precautions? Was it reasonable under the circumstances? Can you protect against every possible risk? No, no one can protect against every possible risk. But if you quit your job, I mean, and this had a sort of two prongs. Number one, let's look at it from the unemployment aspect. If you quit your job because they threw open the doors, they're not giving us masks, they're not giving us wipes, they're not giving us hand sanitizer, and they're just letting every Tom, Dick, and Harry come in, and you quit your job and say, I felt like I had no choice but to quit. It was basically what we would call a constructive discharge. Any reasonable person would not want to continue working there. Unemployment might say, well, the conditions were such that the employer was not acting reasonably and the employee did not voluntarily quit their position. The second sort of issue to look at is wrongful discharge. Would I have a lawsuit against my employer for wrongful discharge? A couple things on that topic. Number one, wrongful discharge requires you to show that the employer fired you for cause, and should not have fired you for cause. As we probably all know, or many of your viewers know, you can't fire someone if they're an at-will employee if the basis is race, color, creed, religion, sexual orientation, all those protected classes. Fire me for one of those reasons, I would have a suit against you automatically in state or federal court for wrongful discharge. Okay. If you're an at-will employee, let's say I work at an office building and they take no precautions whatsoever, and I refuse to come to work, they could fire me. And if I'm an at-will employee, a non-contractual employee, we're really probably talking about nothing, because an at-will employee can be fired for any reason except those reasons, those protected reasons of race, color, creed, religion, sexual orientation, et cetera. So, at the end of the day, I think probably and this is a big topic, there's law review articles that are coming out, law commentators are talking about that. Here's the other aspect of employment or any kind of civil law. You always have a duty to mitigate your damages. So if I'm working at that office building and I'm fired because they're not taking reasonable precautions, as we joked about the other day, I can't sit on my couch and watch The Price is Right and Maury Povich for the next 3 years while I wait for the case to get to court. I've got to go try. The law imposes a duty upon me to try to replace those wages. So if I get a better job in a month or 2 months, or the same job, or maybe not quite as good a job, I'm not going to have a lot of damages, because your damages are really measured by your lost wages. So employment law is difficult in the arena of wrongful discharge, because you have that duty to mitigate your damages. You can't, again, sit on the sit on the couch and eat potato chips and wait for the case to get to court for the big payday. So again, I realize that as human beings in today's world, we crave definitive answers. Well, just Google it and we'll find the answer. Well, the answer is who was reasonable under the circumstances? Was the employer reasonable and taking reasonable precautions, or was the employee reasonable and the employer was not taking reasonable precautions? So I know that doesn't answer your question, but that's the way the law is sometimes.
Yeah, no, I definitely understand. And I think it even applies to what we were talking about yesterday, for those instances where people have underlying pre-existing medical conditions. If the employer, reasonably try to make an effort to accommodate their needs versus not doing so, and going from there as far as, who's at fault. So it's a lot to chew on, but you definitely gave us, plenty.
Well, I had a client yesterday. He's a longtime client. He is a small business owner. His daughter works at a local hospital, and she's like, I don't want to go into work because I'm really scared. I mean, she's like 22 or 23, and she's a nursing assistant, and she's like, I'm terrified to go to work. And I'm on the phone with her and her dad, and I said, Dave, like, I got two answers for you. As a dad, there's no way I'm letting her go back to work, okay? As a lawyer, I'm telling you, she should probably go back to work, because if they are taking reasonable precautions, she's gonna lose her job.
Wow. Well, that sucks, because someone in your position, you understands both sides of the coin.
I mean, I try to. I think that you've got to always take the other side's position into account.
Right.
It's like the offense has got to study what the defense is doing.
Yeah.